and then subsequently there was a statement as to why this body is being set up or was set up. Now, basically, we are here to answer questions that you may have in regard to what we have to do or what we will be doing. And you probably want to know the terms of reference in regard to our work. Now you know that key institutions in this country have suffered a crisis of public confidence and an erosion of the independence, such that the pillars of good governance, including the separation of powers and the rule of law, have been eroded. And there are also various legislations that remove or seriously impinge upon the fundamental liberties provided for in the Federal Constitution and which do not accord with the rule of law. Basically, the emphasis is on the rule of law and accountability. There is a need to strengthen the rule of law. How? By strengthening the institutions and the checks and balances that underpin a democratic system of government. The Council of Eminent Persons, which was established on the 12th of May, recognizing the economic reforms must be accompanied by institutional reform, establishes committee. And what we have to do will be this: to inquire into and examine the present state of key institutions, so as to identify the shortcomings and problem areas, and to examine the adequacy of the checks and balances to ensure the independence of these institutions. To consult all the relevant stakeholders, and in this regard, establish subcommittees, if necessary, to assist the committee and to undertake all such inquiries, examination, or research as is required. And then we have to make recommendations to the government through the Council of Eminent Persons for the reform of the various institutions. We will study all legislation as described in the recital earlier on, which do not accord, all laws which do not accord with the rule of law which relate to institutions, and also to make recommendations to the Council of Eminent Persons as to the repeal or amendment of legislation examined to bring them in line with the rule of law. Again, to make recommendations, if any, as to the requirement of further study or examination as may be required to be undertaken in the future in respect of any other institutions of law or laws. And that's about it, our terms of reference in a general way. And now, if you've got questions to ask, please do ask us. The way would be just address the question, and there are 5 of us here, and the person who's more conversant with the area of expertise that you're talking about will answer the question, right? Please.
You mentioned examining key institutions and things like that. So what right now is your priority and what do you think needs to be fixed?
Yeah, at the moment we have the Attorney General's chambers, or the institution of the Attorney General, and public prosecutor. We also need to look into the judiciary and the setup of the Judicial Appointments Commission. Enforcement agencies, which include the police force, and basically, more importantly, is the police force, and of course there are the agencies. Then we have the anti-corruption agency, and
EC.
very, very important also the EC, Election Commission,
May I ask, you brought up the enforcement agencies, the IPCMC. That's been the authorities have been trying to put that forward for a long time, but it's gone through a lot of resistance. What sort of challenges do you see?
What's that? The IPCMC. Okay, yeah. What sort of?
Yeah, what sort of challenges do you foresee going forward? There's going to be there was a lot of reluctance to implementing that.
Yeah, we'll have a look at it and see why there has been this reluctance. And we're going to interview these people who are in the departments, bodies, institutions to come and explain to us. And let's see how they are going to deal with it and whether they would accept it now or reject it. But we'll have to look at what they have to say, and we have to look at the laws if they think that the laws impede their way of doing things. But let's look at the challenges as they come by. Yeah.
And if I may add, don't forget that we have a Royal Commission that was set up on this very point. And of course, we have to consider those recommendations and have a review of the whole position and see, as you say, the objections. We have to see how the objections now play out in response to the recommendations of the Royal Commission.
May I ask is that do you foresee that every reform would be need to two-thirds majority to amendment the Constitution?
I think some of them may. Some of the reforms that we may suggest may involve amending the Constitution. But there are quite a number which won't involve amending the Constitution. They are possibly structural changes, not just changes in legislation. So we're going to study all aspects and recommend in various cases where there is required constitutional amendment.
In fact, in some cases, there may be no need even for legislation. So, for example, reform of parliamentary procedure, reform of parliamentary committees can be done by amending the standing orders of each house. If there were to be a rule, and I'm keeping the issue open, that the chairman of the Public Accounts Committee shall be a member of the opposition, as in England, that doesn't require legislation. That's merely a matter of Parataran, Devan Raya, Devan.
Importantly, that deals with processes. Yeah? I think the priorities should be what are the legislation that we want to look at, which are the immediate ones that needs attention.
Like the fake news Act, Printing Presses and Publications Act, some aspects of the Official Secrets Act, which basically prevent truth from emerging. I think these need to be looked into.
Yeah, and on that anti-fake news act, we are a little bit confused. is the decision to repeal it completely or to define it to make it clearer? What's the stand on it now?
I think that's something we're going to look at. I mean, we all have our individual views, but I think we are looking at having it repealed in total. So that is what we are looking at. And we are looking at some legislation which can be repealed in total and some which require amendment. And this will include all the draconian laws. I don't have to list them out. I think you all know them so well. Yeah, that's right. And so, yeah, Sedition Act and so on. All of those acts that have impaired our fundamental liberties unnecessarily, things like the Sedition Act and so on, we are looking at. Yeah.
So while no one condones falsity and falsehood, there's something which we don't condone. But we reckon by looking at the existing legislation, there are really sufficient provisions that deal with such situations like that, right? The Penal Code, the Defamation Act, and
Printing
presses and so on. So whether all this will be sufficient without having to have an additional act which makes it so onerous. And the penalties under the Fake News Act is very, very onerous. Yeah.
Will the committee also recommend for all state governments to recognize the opposition and also give them fair allocation? Does that fall under institutional reforms?
Parliament, yes. I mean, that is possibly something we could look at under the parliamentary reform. Yeah.
Will the committee also be looking at boundary changes that were passed recently?
With the EC, yes, there's a lot of work to be done with the EC.
A lot, yes. Absolutely, yes.
Not necessarily. The legislation is one thing, but I would imagine that one of the first things you would look at is to clean up the electoral roll. That is a process that will take 2 or 3 years. So we can make recommendations about that, and then we look at all the other issues. Obviously, there's quite a lot to look at under the EC.
And that may not require constitutional amendments. Actually, the Constitution is quite clear that constituencies must be approximately equal in population size, subject to rural weightage. But how much weightage for a rural versus an urban, I think that doesn't necessarily require a constitutional amendment.
Is there a deadline or when are the first set of recommendations supposed to be expected to be presented to the new government?
2 months, actually. There is a deadline, July. Yeah.
July, yeah.
60 days.
2 months.
So the first thing that you all will look at will be the AG chambers. That's the first
Actually,
on your
it's
radar.
not necessarily that order.
That's right.
Because, quite frankly, people have contacted us already, and we've been in touch with people. There is work that has already been done on many of these areas by organizations like the Bar Council, Lawyers for Liberty, Hakam, and so on and so forth. So we need to collate all of that. Recommendations have been made, but of course we need to update all of that. And then we're going to have inquiries where people will come, will be invited to brief us on their recommendations. And of course the institutions themselves will be invited to provide their input as to how reform can take place.
This is a platform, an opportunity for all relevant stakeholders to come forward and present the case to us for consideration. See, we mentioned these 5 or 6 institutions just now, but it's not necessarily the
It's not exhaustive.
Not exhaustive.
Not exhaustive. Yeah.
Also bear in mind that we'll be dividing a little bit of the work. So a lot of institutions will be looked at concurrently. It's not a case you finish one, then you go to the other.
Do you agree that the government should first have a law minister first? Appoint a law minister in the area of law so that they can study the recommendation raised.
I think what we may look at is possibly a law commission. That was Prof's suggestion. Looking at the setting up of a law commission which can do continuous work of reviewing legislation. But we're looking at it. I mean, there are no recommendations yet on that.
But your statement about whether there should be a Minister of Law is a prerogative of the Prime Minister, right? And in any event, when you have a Minister of Law, he doesn't control the activities of the law. of the Attorney General or the judiciary.
Yes.
He's just a man in charge of the administrative matters relating to these two institutions.
And the commissions that you all are looking to set up, like the Law Commission, for instance, it would be independent. Right? It would be independent and not under a ministry.
In
The
the-
commissions that are set up.
Yeah, that. If we are looking at it, we're looking at it. But if that is one of the recommendations, obviously, yeah,
Independent.
every commission should be independent.
In fact, in some countries, law reform commissions even have the power to initiate legislation, not just to submit recommendations, but to initiate legislation. So all those models will be looked into.
See, further to your question about legislative law, I think we are very aware of the call for a separation of office between the Attorney General and the Public Prosecutor. So that is something definitely that is within our scope of inquiry.
That required an amendment of the Constitution.
Yes,
And that is going to be
that was
something that we'll have to look at,
That's Article
depending on the political
145. Yes.
And will law also be recommending for the EC to be an independent body eventually? Will that also be?
By the way, it's supposed
It's
to be.
supposed to be independent.
By the way,
It's provided for in the Constitution.
correct.
So that was okay.
Yes, you see, but the thing is this, that's why we are also looking at checks and balances, because that is what is going to ensure that every institution remains independent,
That's right.
no matter who is in power. So it's that kind of checks and balances that we need to put in place, that we also are going to consider. Yeah.
You guys have only just started this like literally just one day.
Yesterday.
Yesterday. At a glance, how bad a shape are we in? Did everything you look at make you go?
Well, it's been making me go that way for a long time. Actually, that's personal. But no, we have a lot of issues to deal with. There is no doubt this is quite a mammoth task. And we can put forward the recommendations, and some things can be done quickly. So I'm hoping that we can look at some short-term things that can be done immediately, and then some may be a little bit more long-term. But yes, you see, you can judge how the situation we're in by the way in which the institutions have been performing, right? The public can judge it. So I think there's a lot of work to be done, without a doubt.
If I may add to that, the Constitution actually provides for most of the ideals that we are going to espouse. For example, the Election Commission chief must enjoy public confidence. Yambi Pratanagwam is mandated to appoint someone who would enjoy public confidence. It hasn't worked that way, of course. Parliament is supposed to be enforcing accountability, responsibility, answerability in the executive. It hasn't worked that way. So I don't think this committee is going to bring about a revolution. I think our job is to revive, remind people what the Constitution says. And of course, if there are areas where we need to make some changes, we will. But the institutions are in place. Many of the laws, good laws, are in place. But the sad thing is laws and institutions are as good as the people who administer them.
Absolutely.
And I think that's where our problem lies.
I think by the time we finish, I hope it will be a silent revolution.
No, but I think apart from that, we will have to look at some of the appointments which only the Prime Minister can recommend. Because that is what has caused the centralization of power in the executive. So we will look at that and see whether it can be more independent of the executive, of certain appointments that are made. So that is something we will also look at.
See, if I may add to
removes
that,
the centralization of the power.
If I may add to that point, while the law provides and sets out the various provisions, there's also always provision for discretion by whoever is exercising those duties. The question is, if there's an abuse of discretion, we want to see what the checks and balances are to make sure these abuses don't occur or don't recur.
May I have brief regard the travel ban on the former Prime Minister?
It's within our scope, but you can ask us individually later.
So
Not part of the scope of
it's
this.
a mandate, it's 100 days, just like the council.
Not 100, it's, we've got 2 months. Because we need to report, we're going to submit our recommendations through the council.
Hi, can I ask something maybe a bit sticky at this point, but even coming up in the years coming up to this election, there's been quite a grey area concerning the divisions between secular law and Sharia law in the country. I think I spoke to you, Professor, regarding this before. This directly involves institutions, the dual track system, etc. Is there work that can be done to clarify what are very muddy waters at this point? There is a lot of cases.
Well, yes, Article 121 brackets 1A does have some problems, but we have recent decision from the federal court on that point, that the Sharia courts are independent of the civil courts in matters within their jurisdiction. But when Sharia courts exceed their jurisdiction, then the case of Indira Gandhi says that the civil courts will have the judicial review power to say so. Well, we'll certainly look into this, but this is not an easy matter, because don't forget, the problem started in the 80s, magnified in the 90s, and became critical lately. But surely we'll look into it.
But this will come under your scope.
Not really. It doesn't really come within our scope. Because at the moment, we've been tasked to look at the more problematic areas of governance, corruption, and of putting in checks and balances. Peripherally, we may have to deal with the matter, but it won't be within the scope of our work.
But let me add that we won't stop anyone putting forward any proposals that they may have in any area, and then we will deal with it as well.
I suppose the closest connection there would be when we look at the judiciary as an institution, then we look at jurisdiction and so on. And of course, we have to consider what is applicable, or what is actually the actual situation in Malaysia.
Sorry, if I may add to my question, because we get government departments not citing court orders, but instead citing fatwas as the basis for their decisions. So these are certain things that maybe need some clarification, when the government officer has to act within his duties as a civil servant.
The Abdullah case.
And there seems to be different opinions about how to proceed with things like that.
We'll look into it.
I'm sure it will come up. When we hear from the public, I'm sure issues develop.
Can I ask, how would your recommendations for the judiciary reform look like, and might it involve the dismissal or reshuffling of judges?
Judiciary?
Oh. Is it under this?
The last thing you want to do is for political interference or executive interference with the judiciary. And what requires to be done would be actually to get the right people as judges. And maybe we'll have to look at the Judicial Appointments Commission as to how these people can be appointed. Because at the moment, the Judicial Appointments Commission is very top-heavy. Can you imagine, to select judges, you have got a top-heavy, what you call, group of people making decisions. 5 judges sitting on the what you call board or the commission, and you've got 4 or 5 others, and most of them being previous retired judges. Nobody from the what you call bar council.
Academic.
There's one academic now, and the judges who sit down there will be the Chief Justice, the 2 Chief Judges, the Court of Appeal President, and they make decisions. Now, would you think that they won't pay deference to the Chief who says, I want this, I want that? No, something has to be done. In the English system, for example, the man who sits in the Judicial Appointments Commission is a non-lawyer. And he sits to give direction, and you've got 2 or 3 judges, the rest are people who are lay people. And I think that's what we should be moving towards, And of course, there's also the other system, which I think has created a lot of problems. If you submit names, judicial commission submits names to the Prime Minister, the Prime Minister has the right to say, I don't want. He doesn't say he doesn't want, he'll say, send me more names. That's like rejecting the people who have been put up. And you know many judges who are exemplary in their work not being promoted. And that's something that we want to prevent. In England, if the authority that rejects the what you call name that is submitted he or she has to give reasons for the rejection. I think we need to do something about revamping the Judicial Appointments Commission law.
I think it's very important that somebody from the profession be in the